Plaintiff refused to hand over the minor children, has refused for months to cooperate and co-parent with defendant, has continued in a campaign of alienating the minor children against defendant.
Ms. Bird's child support obligation was less because I had her paying directly 1/2 of the child care amount. But when she stopped paying her 1/2, then that put the entire obligation on Mr. Fields, which was never contemplated.
Defendant father was the go-to parent for the children and oversaw their activities, assisted with homework, prepared meals, oversaw medical appointments in his role as a stay-at-home father, which he's been for the last 7 years.
After plaintiff had worked a 12-hour shift, he then taunted and laughed at plaintiff after she requested that he put her phone down. He then ran into the bathroom and locked himself in with plaintiff's phone so that he could go through it.
Mr. Todd, I don't care what your belief is. I care what the facts are. So, you can leave your beliefs out because that doesn't matter.
The children had lived with my client at the request of the plaintiff. And over the past year, the plaintiff has had only 4 overnights with Avery and rarely sees him. She has parenting time with Evie on the weekends.
The testimony that she refers to is not the testimony that's in the transcript.
Well, Ms. McNiff, are you making up testimony then?
He has specifically said in text messages, if I get her more, I pay less, because he wants to pay less child support, Your Honor.
Court will note the appearance of Ms. Capture on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Capture.
Thank you, Your Honor. I won't go through the process of repeating what was in our motion and complaint. However, I do want to address defendant's answer directly. First and foremost, defendant describes an incident that occurred in 2023. However, the description in defendant's answer is incorrect. Defendant took plaintiff's phone on a Thursday evening after plaintiff had worked a 12-hour shift. He then taunted and laughed at plaintiff after she requested that he put her phone down. He then ran into the bathroom and locked himself in with plaintiff's phone so that he could go through it. Obviously, plaintiff was upset about this. She exited the home to cool off, and instead defendant took himself and the minor children and went up to a window and essentially just taunted plaintiff. Unfortunately, this type of behavior has continued now into this next year, where the two parties should not be within the home together. So plaintiff made the decision to leave the home. She has been getting parenting time essentially every single day. She does work 40 hours a week with 12-hour shifts. Our parenting time schedule that we have requested includes overnights because defendant has absolutely refused to allow plaintiff to have overnight parenting time, and stated on multiple times that he would not even allow plaintiff to see the minor children if she did not return them home, despite the fact that plaintiff does have adequate housing for the children to stay with her. Again, plaintiff is full-time employed. She does not have an issue with marijuana or whiskey, as defendant alleges. Defendant grew marijuana for a long period of time. I don't believe he does any longer. However, both parties have abstained. Plaintiff is no longer utilizing prescription drugs. She has abstained from those as well. With the Wellbutrin and the Adderall, they have been prescribed to her. However, she's no longer using those. Again, Your Honor, plaintiff is a loving and caring mother. She has a great relationship with her 2 children. Defendant has prohibited her from having adequate parenting time with her kids due to her work schedule. She believes that the requested parenting time, 4-3 parenting time, is an adequate parenting time schedule, with both parents sharing joint physical and legal custody. The parties are able to agree on legal issues. There doesn't seem to be any issue with regard to that with the minor children. Thank you, Your Honor.
Okay, thank you. Ms. Thomas?
Thank you, Your Honor. I think it's important to note a couple of things. Well, first of all, it's notable, I think, that it appears that plaintiff's counsel just admitted that although the plaintiff is prescribed medication, she's not taking that medication. So that's a little bit of an even greater concern. The two children are 9 and 3. They separated approximately 2 months ago. And since that time, the children resided with defendant father. He's ensured that the plaintiff mother has had daytime parenting time approximately 5 days a week. And now with her latest change in her work schedule, about 4 days a week. The schedule did change a couple of times, first when the school started so that the kids came back earlier, and then now mom's working different days. So currently parenting time is based upon mom's work schedule, and she now works 12-hour shifts on Monday, Tuesday, Wednesday, and then a half a day on Thursday. So she gets Rosie at about 1 o'clock on Thursday, and then picks Cam up from school, and then dad picks them up between 7 and 7:30 on Thursday. And then on Friday, the schedule is the same, other than he picks them up between 8 and 9. Saturday, she has both kids from like 1 o'clock until 9. The parties, we disagree that the parties have effectively co-parented during their relationship, and for the reasons detailed in defendant's answer to the motion, plus the fact that plaintiff has told defendant and acknowledged to defendant that she is aware of her drinking problems. She is aware that she drinks or that she smokes too much weed. She said she doesn't want to be here anymore. And when asked about, well, what do you mean? And she said, I don't want to be on earth anymore. I mean, there's some things going on with mom that we need to make sure are taken care of before we put the children in a situation. And we think that the extended longer periods of parenting time are the problems, and the kids, they don't want to go. Their demeanor changes when it's time to go. When they're very excited to come home. They report all kinds of things, obviously, that I'm not at liberty to state right now, but certainly I've heard some things that they've said that is very concerning to me. And we're asking that the current parenting time schedule continue the status quo until such time as the parties can either participate in mediation and or an evidentiary hearing is held, and or plaintiff mother addresses her alcohol abuse and mental health issues. It is notable that plaintiff mother's requested parenting time plan would not allow defendant father any full weekends of parenting time, which would not be equitable as far as that goes. Defendant father agrees that for stability, the children do need a temporary order. It is necessary. However, it should be a continuation of the current schedule. During the parties' relationship, they were not equal when it came to caring for the children. Defendant father was the go-to parent for the children and oversaw their activities, assisted with homework, prepared meals, oversaw medical appointments in his role as a stay-at-home father, which he's been for the last 7 years. Once he realized, and he did that, once he realized the extent to which the plaintiff mother, she was supposed to only be working part-time, then she went full-time without discussing it. And he couldn't do his business out of his home and do everything for the kids too. And when she got pregnant for Rosie, and then had the baby, that he couldn't take care of a toddler and run his business. So he closed his business to continue in the role of a stay-at-home father. Her use of alcohol and her habit of using, and I understand what counsel said, but her use of marijuana and continued drinking while she's on prescription meds and then now not taking her prescription meds is very concerning. It's concerning that both because what does that do to her mental health issues, but also that it's just at a situation where it's very concerning about what has happened. She's very rough with a 3-year-old, and it's very concerning. Defendant father was hired by Duncan Aviation last week. He starts in a couple of weeks. And once he gets his first paycheck, of course, we think that child support should be set pursuant to the Michigan child support formula. That's fine. But in the meantime, we're asking that due to the ongoing health and alcohol abuse issues by plaintiff mother, the defendant is requesting sole custody with parenting time as described. And then we're also requesting an order for a psychological evaluation and drug alcohol assessment for the plaintiff, with the requirement that any treatment recommendations be followed. We're just very concerned about the safety of this, especially, the older one is 9 and he's old enough that, he can tell you, but she's 3, and it's very concerning. It's very concerning that not only what her brother says, but that her older sister, who is actually the plaintiff's daughter and not the defendant's daughter, but has chosen to live with the defendant, it's very concerning that some of the things that they are reporting that happens, and how rough that mom is with Rosie, who is again only 3. We're simply asking that we look out for the best interest of the child and make sure that she's safe and secure in a stable environment. And therefore, our request is as we've stated, but specifically with a parenting time as currently has been happening.
Okay, thank you. Well, the court notes there's a lot of allegations and again, that's proceeding in this case, but the fact is the parties have noted and the defendant has noted as well that the plaintiff has been receiving the children either 4 or 5 days per week, just not in the overnights. So the court's taking that into consideration to show that the children have spent a substantial period of time with her. What the court's going to do on a temporary basis to preserve that, court is going to grant to the parties joint legal and joint physical custody, and the court will award parenting time as per paragraph 15 of the defendant's or plaintiff's motion, which would be a 4-3-3-4 schedule, as well as alternating holidays. And court will set the support based upon the income of the parties. That's the plaintiff has stated that she's making $47,000 per year, and now the defendant is making $24 an hour. A court will order that the parties would meet at a 1/2 half point between their residence to exchange the children. And I'll leave that up to the attorneys to work out where that 1 halfway point will be, and would order that the parties would abstain from alcohol or non-prescription drug use during the time that they have the children in their care. That will be the extent of the order. I'll ask Ms. Capture that you would prepare that. You can submit under 7-day notice.
Thank you, Your Honor.
Okay.
Judge, I do have other cases at the same time. Do you want me to just stay on?
Yeah, we'll probably put you back in the waiting room until we can get all the parties present.
Thank you, Your Honor.
Court will note the appearance of Mr. Unlough on behalf of the defendant. This matter is before the court on the defendant's motion to modify custody, parenting time support, and for psychological assessment. Go ahead, Mr. Unlough.
Your Honor, the parties in this case have 2 children, Avery, age 15, and Evie, age 9. Their order regarding custody was entered in October of 2018, gives the parties joint legal custody, joint physical custody, and equal parenting time with a schedule of alternating weeks and alternating holidays. Since August of 2023, however, the children have lived with my client at the request of the plaintiff. And over the past year, the plaintiff has had only 4 overnights with Avery and rarely sees him. She has parenting time with Evie on the weekends. During the summer, she has been struggling with her mental health. She's messaged my client stating, maybe Evie should be with you. All I do is cry. I'm failing. I can't keep my emotions under control. I don't know if she should be around me. That was attached as an exhibit. Evie has sent a disturbing text message to my client asking to be picked up, saying, Mom's still screaming. Please, I need you. Evie's teacher has reached out to my client with concerns regarding Evie's mental and emotional health. Plaintiff even filed a motion herself on May 8th of 2024 requesting a reduction in her parenting time to every weekend, but then failed to appear at the hearing, which resulted in it being dismissed. My client, on the other hand, is stable and has a strong and loving bond with the children. We're requesting that the plaintiff have a psychological assessment by Dr. Randy Haugen or another professional recommended by Dr. Haugen and follow the recommendations in that assessment. We are requesting that my client be awarded sole physical custody of the minor children and that the plaintiff be ordered parenting time on alternating weekends year-round with alternating holidays, a modification of child support pursuant to the formula based on the changes we've requested, and further request that the court remove the requirement that the defendant not have access to the controlled substances of any children's prescription from a pharmacy and only get them from plaintiff because the parties have not followed that provision for years. Thank you.
Okay, thank you. Ms. Owen, what's your response?
On May 8th, I did file a motion requesting every weekend instead of weekday parenting time because I work a full time schedule, and I didn't have the ability to pick Evie up from school or to take her to school. It was dismissed because I couldn't leave work to attend the meeting for the kids at the courthouse. And at that time, Stephen would not agree to me having less parenting time with Evie. I filed for child support, and straight away he retained an attorney and filed for sole custody. Since August of 23, the children have lived mostly with Stephen upon an agreement between the two parties. Aaron was going through a divorce at the time, and we found that to be necessary. Over the past year, Avery hasn't wanted to have many overnights with Aaron. Aaron supports Avery's decision as he has autism and change in routine is very hard for him. And he is 15 years old now. I did have Evie on weekends throughout the summer. I work 45 to 50 hours a week all summer, making it really hard to have her during the weekday, especially when she's not at school. I have struggled with my mental health since being diagnosed with Addison's disease 6 years ago. I take medication as prescribed. I see a therapist regularly and follow up with my providers as I am requested. I am stable, and I go to Bronson Internal Medicine and Lifetime Wellness. Evie's 4th grade teacher last year did make claims against me. This teacher was taking Evie during her before school care alone to her classroom inappropriately. It was determined that this teacher had been grooming Evie, and the school has taken corrective action. So during my divorce and going through a mentally hard time, I did message Stephen for support, telling him that I was crying a lot and that Evie shouldn't be around me at that particular time. This was back in March of 24, so not current. Evie did text her dad one time while she was at my home asking for him to come get her. I told her that was fine to do so. This was back in January of 24, so that was not current either. I am asking that the court order physical custody stay at 50-50. I'm asking that the court order Aaron to have parenting time alternating weeks with Evie and Avery should have his own choice. I want the court to order, I would like the court to order medication provision to be removed. I would also ask the court to order child support according to Michigan child support formula. I would like the court to order Stephen to pay for my psych assessment and follow-up recommendations, including missed wages if the court finds an assessment necessary.
Okay, anything else?
I would like the court to order the use of a court-approved parenting app for communication between co-parents.
Mr. Unlough, do you have any opposition to parties utilizing like Our Family Wizard or App Close or something of that nature?
I personally do not, but I would ask my client if he has any opposition as well. I would ask my client to confirm whether he has any opposition.
Okay.
Mr. Frazier, do you have any issue with using Our Family Wizard or App Close to communicate?
No, I can do that. That's fine.
Okay. Just wanted to be sure.
Well, I ask Mr. Unlough that you would prepare an order to that extent, that the parties would utilize a communication app such as Our Family Wizard or App Close. And the court does find, even based upon the plaintiff's acknowledgments in this particular matter, that there is proper cause or change in circumstances sufficient to modify custody and perhaps parenting time in this matter, but I cannot do it without an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter on that issue. The rest will, again, we'll just have to address at the time of the evidentiary hearing. I'm not going to order, again, psychological assessment. I'm not going to do that because apparently from what Ms. Owen has stated herself, she acknowledges the mental health issues. So I don't know what would be the benefit of having someone can affirm and corroborate her own statements in this matter. So I'm not going to order it at this time, and we'll just proceed, and we'll be in touch with you about an evidentiary hearing.
Your Honor, one more thing. I believe based on Miss Owen's response, we do have an agreement to have the medication provision in the order removed.
Okay.
May I include-
Someone, is that, I think that was what you stated, to have that removed, correct?
Yes.
Okay. Mr. Unlough, just include that in the order with the communication as well.
Thank you, Your Honor.
Okay. Thank you all. We'll be in touch with you, and you're free to go. Have a good day. Court will note the appearance of Ms. Henderson on behalf of the plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the defendant's amended motion to show cause. I think your motion pretty much speaks for itself, but Mr. Todd, it's my recollection that I got an order in ordering the counseling with comforts of home I signed that earlier. Is that accurate or what?
Yes, Your Honor. In essence, the parties agreed to use comforts of home, and that's fine, but the agreement was made on 6/10, and there was a prior order in essence from the referee. It's been more than 3 months at this point, and the child is still not in counseling. There's in essence in a response indicating that there was difficulty between the intake and scheduling. However, even in their own response, there's a voicemail from August 13th, and then the plaintiff waited 2 weeks to call back to set that up. There's really no reason why counseling hasn't occurred yet. Additionally, the referee ordered previously that Meridasa Cats would no longer be the counselor, and comforts of home, or an agreed upon counselor would be used, which is comforts of home, which we agreed to. So this is just a continuation of, unfortunately, Miss Fletcher preventing the child from going to counseling. Additionally, there has been a failure to use Our Family Wizard as well. The order it's a prior order, but for example, we have a period of 16 days where the plaintiff has failed to use Our Family Wizard. Additionally,
Mr. Todd, if I want to interrupt, first, there's a couple things. So your show cause has to do with 2 weeks that she didn't respond, and the fact that she didn't use Our Family Wizard for a number of weeks. And because it's my understanding the child is scheduled for an appointment as per the answer for the 18th.
That's correct. And we believe that only actually happened after we filed this, because the agreement was 3 months ago that she would use.
Okay, Mr. Todd, I don't care what your belief is. I care what the facts are. So, you can leave your beliefs out because that doesn't matter.
Sure. It's been 3 months though, and I don't understand why it's taken this long.
Okay. Well, Ms. Henderson has filed an answer effectively denying those. I don't see how I can proceed today without having an evidentiary hearing in this matter. So
Sure.
the court is going to reserve on the show cause pending further proceedings on an evidentiary hearing in this matter. So we'll be in touch with both of the attorneys' offices to set that hearing up.
Thank you, Your Honor.
Okay, thank
Your
you.
Honor, may I please inquire about our request to return to Meridasa Cats, Your Honor? There were never such scheduling conflicts with her. She's a lot more flexible to accommodate Macy, and Macy has been seeing her for a long period of time.
You stipulated to comforts of home.
We did, Your Honor, but given the difficulty of scheduling, given how the counseling office has kind of interjected itself and not given all the facts in the letter that they produced for Mr. Todd, how my client had to chase him for an explanation, we're asking that the child be returned to Meridasa Cats. The only reason the counselor was changed was upon Mr. Franzman's request, following Ms. Katz's
Which you
testimony.
consented to.
We did, Your Honor, but now we're asking for a change at this point.
I'm going to deny your request. That will conclude the matter. And if you want to, Mr. Todd, you can do a order denying the request to change it back to Ms. Katz.
Absolutely.
Okay.
Absolutely. Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Smith on behalf of defendant. This matter is before the court on the defendant's objection to the referee order. Ms. Smith.
Yes, Your Honor, ultimately, my client and I are asking for a new evidentiary hearing in front of the judge or for the court order to go back to the previous court order. There were many errors made in the referee's order and a recommendation as far as to the testimony and how the testimony was interpreted by the referee, how he applied it to the recommendation. He stated that there were domestic violence issues in Miss Benjamin's home with her current live-in boyfriend, to which there were 3 people who testified that there are no domestic violence issues. He also stated that the current live-in boyfriend, Mr. Wilk, has an alcohol problem. Mr. Wilk testified that he does not, as he is on a medication that prevents him from drinking for his liver. There was a significant amount of parenting time taken away from my client, in which the referee did say that it was important for the parent-child relationship between my client and her son to get better, but ultimately that is not the case when she has no parenting time basically with her son, as in the recommendation, the referee ordered that the minor child is not allowed to be in the presence of my client's live-in boyfriend, who lives in the home and who also shares 3 children with my client. So it's not incredibly 2 children, I'm sorry, with my client. So it's not incredibly feasible to have him out of the home while she is having parenting time, which is only every other weekend currently with the child here in question. There were various testimony that was taken. I'm not sure if it was taken out of context or if it was just misinterpreted wrong. For example, in the referee's order, he stated that one of the witnesses stated that they have a criminal history and they have a drug addiction problem, but that was not their testimony. So based on these errors, we would just ask that there is a new evidentiary hearing with the judge, or that the current court order go back to the old court order. Thank you, Your Honor.
Thank you. Ms. McNiff.
Your Honor, I believe the standard is that there has to be a showing that the referee either made a legal error or a factual error. And the misinterpretation of testimony comes down to a very subjective view. There were a lot of witnesses who testified. A lot of the witnesses were contradictory in terms of their testimony. And from my understanding of the referee's finding, it came down to credibility. I would disagree that there weren't witnesses who testified regarding drug issues. I believe there were 2 witnesses who confessed that they had serious drug issues and in fact had been incarcerated in the past for drug issues. But I believe this goes to the weight of the testimony. It doesn't go to a legal or a factual error. In the event, however, that the court does want to review this, I would certainly suggest that the transcripts be ordered by Ms. Smith so that the court could review them. But we believe that there's no basis for setting aside this order.
Okay, thank you. Anything else?
Your Honor, I'm sorry, if I may, Your Honor, we do have copies of the transcript. Unfortunately, it took probably almost a month to get the copies of the transcript. We just received them, and so I was able to go through, and there is a lot of factual error from the transcript and from the referee's order. So we do have those copies of the transcript, Your Honor.
Okay. Well, the court will note that factual error doesn't exist just because you disagree with the particular facts or you disagree with the particular testimony. The court has reviewed Ms. McNiff's answer, and she highlights testimony that does support the referee's order and decision in this particular matter. The referee did acknowledge that credibility was a substantial issue in this matter. I think when you couple that with the highlighted testimony that Ms. McNiff cited in her particular response, the court does not believe that the referee made a factual or legal error in this matter, and as a result, the court is going to deny the objection. That will be the order. You're free to go. Have a good day.
Thank you,
Your,
Judge.
Your Honor,
Yes.
if I may, after reading Attorney McNiff's response, the testimony that she refers to is not the testimony that's in the transcript.
Well,
We can provide the transcript to the court and to Ms. McNiff, but the testimony that she referred to is not the testimony of the witnesses in the transcript.
Ms. McNiff, are you making up testimony then?
I don't believe so.
Okay.
I haven't reviewed the transcripts, but my notes, I take a lot of notes during trials, and my notes are pretty clear that there were 2 witnesses that admitted drug use in the past, not.
Yeah. I don't see any basis for this court to, again, address the matter further. As I stated, I'm going to deny the objection. You're free to go. Court will note the appearance of Ms. Jordan on behalf of the plaintiff, Mr. Unlough on behalf of the defendant. This matter is before the court on the plaintiff's motion for modification of custody, parenting time support, and for use of our family wizard. Ms. Jordan.
Thank you, Your Honor. I believe that our motion speaks for itself. We do believe that there has been a change in circumstances sufficient that custody, parenting time, child support should be modified. We also believe that there has been a breakdown in the communication sufficient that a co-parenting communication app such like Our Family Wizard would be helpful for both of these parties. There has been CPS investigation. There have been mental health concerns. The judgment of custody entered over or nearly 4 years ago at this point. And there has been a substantial change in circumstances as is outlined in our motion. So at this time, Your Honor, we would ask that this honorable court either modify custody and parenting time in the best interest of the minor child or set the matter for a full evidentiary hearing so that custody and parenting time can be modified.
Okay, Mr. Unlough, your response. You're muted, Mr. Unlough.
Oops. Your Honor, I think our response also speaks for itself. I'll just point out the highlights. The mental health issues that opposing counsel is referencing happened almost 2 years ago, and the plaintiff did not file any kind of motion at that time. My client did have a mental health issue in September of 2022, but she did the appropriate things. She made an emergency appointment for a psychologist and treated with that psychologist. That incident is an isolated incident, and again, it occurred 2 years ago, and it took the plaintiff 2 years to raise this as an allegation. It clearly wasn't concerning to him 2 years ago, or he would have filed this motion 2 years ago. As it relates to the CPS investigations, yes, there were 2 CPS investigations into my client. However, I confirmed with the investigator that neither investigation resulted in my client being substantiated for anything. They were simply closed. As it relates to the allegations regarding my client's significant other, she has looked into the allegations. There have been no charges, no CPS investigations. She has notified the plaintiff about these allegations. The plaintiff said he was comfortable with the minor child being in the presence of my client's significant other. There have been no incidents. For all of those reasons, we are requesting that this motion be denied outright. Thank you.
Okay, thank you. Ms. Jordan, any reply?
Yes, just briefly, Your Honor. While the CPS investigations, I don't have the records back yet. We did subpoena those. We're unsure if they've been substantiated or if a formal case has been brought. However, the nature of the allegations are still concerning. The minor child got a hold of Motrin. That is in our motion, and it's also in defendant's response that she did drink Motrin under defendant's care. That is quite concerning. All of this was going on while CPS was investigating. As for the allegations against defendant's significant other, I don't know what kind of training the defendant has in order to investigate those and be the authority to say that they are simply not true. There are concerns regarding the individuals that are cohabitating in the defendant's home that are laid out in our motion. There are substantial concerns about the minor child's mental health here and the deleterious effect that some of this has had on the minor child. There are also allegations of substance abuse and substance use in the defendant's home. It's not just the mental health incident. It's not just the CPS incident. There are things going on here, Your Honor, that warrant a modification of the custody and parenting time arrangement.
Okay, thank you. Well, the court has read the pleadings in this matter, and I will state that obviously the allegations are troubling, but Mr. Unlough has filed his response, and if, again, the response turns out to be true as at the time of an evidentiary hearing, then there would not be a basis for modification. But at this point, we have the allegations and we don't know what the proofs are going to show. So the court will find that, again, there is sufficient basis for an evidentiary hearing, and that will ferret out whether there's any truth to the allegations or not. So the court's going to refer the matter to the referee for evidentiary hearing. The court will likewise order that the parties would communicate through our family wizard in this matter, and that will be the temporary order in this case as we wait for that evidentiary hearing.
Thank
Okay.
you.
Ms.
Thank you.
Jordan, you can prepare an order that would provide for the our family wizard, and court will do the order referring to the referee.
Thank you, Your Honor. Just
Thank you.
briefly, how would this honorable court have us split the cost of our family wizard, or would this court like us to try to do the fee waiver?
Well, that'll be up to you, but the obviously if the parties will have to pay their respective costs to be again involved in our family wizard in the event that they can't get a waiver.
Thank you, Your Honor.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Ms. Capture on behalf of the defendant. This matter is before the court on the plaintiff's motion to suspend parenting time. Mr. Schaefer.
If it pleases the court, Your Honor, I have reviewed the answer. There are substantial numbers of factual issues here. But what I allege to the court is that on August 26 and 25, there was erratic behavior on the part of the defendant father herein, where he shows up at a place at my client's residence, contrary to what the agreement was as to where they were to exchange the children. He was erratic. He blocked off my client, made an effort to put himself in harm's way of jumping out of the car and saying, "Run me over, run me over." He beat on the car. He beat on the window where the children were at. My client had to avoid it out of her drive and onto the road. He chased them at close distance, tailgating them. 911 was called. He was arrested for domestic violence. Subsequently, there's a PPO that was issued against him. The children had a substantial meltdown as a result of this, and they are very fearful of him. They will not go with him. They have texted him and so indicated. This is coupled with he has mental illness. He's been in counseling. A report that I have in front of me as of January 24th of 23, he was diagnosed with severe depression and other anxiety characteristics with a lot of recommendations. We believe that he is suffering from the mental illness, and as a result of that, the children are in jeopardy. If these things are being refuted, as the answer indicates, then I think we need an evidentiary hearing so that we can sort this out. But right at the moment, the behavior of the defendant at this point in time is egregious, that he is facing criminal charges as a result of his actions in August, and there's a PPO that's been issued. So we ask that our motion be granted, and if the court believes there's factual issues, then I'd ask there be a evidentiary hearing. Thank you.
Thank you. Ms. Capture?
Your Honor, in our answer, we made it abundantly clear that there's a gross misrepresentation of the allegations that plaintiff is asserting, namely that There was no agreement as to where to exchange the minor children. Defendant was well within his rights to appear at plaintiff's home to be able to exchange the minor children. Plaintiff refused to hand over the minor children, has refused for months to cooperate and co-parent with defendant, has continued in a campaign of alienating the minor children against defendant, is now claiming that defendant has mental illness and severe depression, which is factually incorrect. And any kind of documentation that plaintiff may have in her possession is has not been disclosed to defendant. And if it is his private medical records, how she obtained those is questionable on top of that. Plaintiff did submit this for an ex parte suspension of parenting time. Defendant and plaintiff had agreed that the minor children would come to defendant's wedding 2 weekends ago, I believe, or the 1st and the 3rd, I believe. Plaintiff refused, even though I communicated directly with plaintiff's counsel to state your ex parte has been denied, your parenting time, her defendant's parenting time is not suspended, and the children need to be made available, at the very least, made available for exchange. However, plaintiff wouldn't even go to that extent, would just absolutely refuse. Plaintiff is not cooperating with this court's orders, hasn't cooperated, and defendant has lost over 18 overnights with the minor children because of plaintiff's campaign against defendant. Again, Your Honor, whatever allegations regarding the PPO and the alleged domestic violence, those are being handled separately, and in fact are likely to be dropped. Well, maybe not the PPO, but at this point, they have nothing to do with the parenting of the minor children. Again, plaintiff continues to alienate the minor children from defendant by saying he's this monster when in fact he just isn't. So we're asking that plaintiff's motion be completely denied, and that plaintiff be held in contempt for continuous violation of the court orders, and defendant be able to have his makeup parenting time at his discretion. Thank you, Your Honor.
Thank you. Well, what the court's going to do is obviously there's sufficient substantial allegations in this matter that the court believes they do need to address. The court is going to set that for an evidentiary hearing. We'll be in touch with both of the attorney's offices to schedule a time for that to occur. Up until that time, as it does appear from even the answer, that there is, again, a tacit admission that there was, again, a change in the pickup point. And obviously that created a number of issues with the kids, with the defendant just showing up at different locations or demanding different locations than the parties had utilized. What the court's going to order is that the parties would meet at a 1/2 way point at the police station nearest to that halfway point. So I'll leave it up to the attorneys to figure out what police station that would be that the parties would meet at, and then we'll schedule the matter for hearing. So that will be the order.
Thank you, Your Honor.
Thank you. Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. McKenzie on behalf of defendant. We had 2 prior issues before the court that were resolved, and the only one remaining is the defendant's motion for credit on child support. Is that accurate, Ms. McKenzie?
Yes, Your Honor.
Okay. You can go ahead, but I don't need to reiterate your entire motion. I've read all that.
Thank you, Your Honor. We are looking for credit on Ms. Bird's child support account of $1440 for overpayment of childcare obligation and $2917.36 on her health insurance obligation. And there are a couple things I'd like to point out. The uniform, as to the health insurance reimbursement, not reimbursement, but a credit on Ms. Bird's child support account. The uniform child support order drafted by the plaintiff required Ms. Bird to pay health insurance if it did not exceed 6% of gross. In fact, it did. And she did not have any obligation to file a motion to say, I don't want to pay because it's more than 6%, for the reason that the existing order, March 7th, 24, already contained that provision. And as a practical matter, the boys did not lose a single day of coverage. She did cancel that in the middle of April, but the policy at that point was in a state where it went through the end of May anyway. And she did have the policy, and I do have proof, which I think I provided to Ms. McNiff, indicating that the doctor's urgent care group benefits confirmation document, that doctor's urgent care group did show coverage from April 1st all the way through November 30th of 24. Ms. Bird did, the coverage actually ended on June 30th of 24. Ms. Bird had was working contingent at the urgent care rather than full-time, expecting to be going to take a position in Tennessee, which as it turned out, that particular job did not materialize, although she is employed now. With regard to the child care credit of $1440 that we seek, she was never required, never ordered to pay directly to Debbie, the child care provider. So that's where I think the fatal flaw is in the plaintiff's argument today. And she was paying what was court ordered, which was around $137 in child support, and that was being paid to the plaintiff through the child support court order. So our position is that that there was never an order for her to pay directly to the child care provider. And just for the court's information, I think Ms. McNiff would be aware of this. The daycare provider I'm bringing this up because this was in Ms. McNiff's answer. The daycare provider is retiring, was retiring and is retired since Grady and one other child started school. And Grady started on August 19th. So Ms. McNiff's response indicates that my client was obligated to pay Debbie, the daycare provider, from the time that Ms. Bird had her parenting time with Grady this summer, from June 23rd to August 11th. The plaintiff's responsive answer indicates that Ms. Bird was obligated to continue to pay childcare when it was entirely unnecessary. She had the child, but in addition, the argument was, in the answer was that she should have paid all through the summer in order to hold the spot for Grady. Well, Debbie's retiring. Grady was going to school on the August 19th and did in fact go to school August 19th. And on August 11th, why was there a need to pay 4 days of childcare all summer? And why, if childcare was necessary between the time that the exchange took place on August 11th between the parents and August 19th when Grady started school, although there's a weekend in there, of course, there would be no reasonable economic need to pay Debbie for doing nothing all summer, and knowing that she was retiring anyway. So other babysitters have been employed by the plaintiff upon occasion when he's needed childcare when Debbie was not available. So responding to that position that was brought up in the answer, that simply was unnecessary. That was wasted money. But in any case, we're asking that since there was no court order that requiring childcare payment directly to Debbie, that the court give a credit for the payments that Ms. Bird did make directly to Debbie, despite there being no court order, of $1,440, and then a credit on the health insurance, which was not required either, because the health insurance premiums were well over 6% of her gross income. Thank you, Your Honor.
How'd you come up with the $1,440? As I see it, she paid that for March, and I think if as Ms. McNiff notes in her answer, that your client was supposedly stopped paying that in May, the child care credit. So why would she be getting more than those?
1440 is what she is due from March to May when she stopped paying. And I did have a typographical error in number 9 when I indicated that she had paid Debbie directly until June 23rd, 2024. I do have a typographical error in that. She paid on May 24th of this year. Ms. Bird made her final payment, and that was for the period ending May 20th. So I've got proof of the payments that she was making, several $100s. One was, I think, a $240 payment, and all of that was furnished. Ms. McNiff, I don't think questions the
I
1440.
understand, but under the UCSO, she was only required, as you stated, to pay 137. So why would she have paid more directly than what she was required to pay under that support order?
That was a mistake.
Okay.
And that, as I've mentioned in the pleadings.
Okay. Ms. McNiff?
I think I answered the allegations pretty thoroughly in my motion and also in the letter that I attached that I had sent to Ms. McKenzie. But essentially, the parties had been each paying 1/2 of Grady's childcare directly to the daycare provider, Debbie. And so when I prepared the child support order, I reflected that arrangement in the child support order. While the court didn't specifically say that each party would pay the childcare provider directly, that had been their practice. And so I assigned each of them $435 per month, which was based, of course, on taking the monthly amount and dividing it by 26 pay periods in order to get the proper amount. And as a result of that, Ms. Bird's child support obligation was less because I had her paying directly 1/2 of the child care amount. If I had assigned that entire amount to Mr. Fields, the child support, of course, would have gone up because Ms. Bird would have been still paying her portion of it. She just would have been paying it to Mr. Fields rather than directly to the daycare provider. But when she stopped paying her 1/2 in May, then that put the entire obligation on Mr. Fields, which was never contemplated. The child didn't go to his mom until in June for parenting time and didn't start school until, as Ms. McKenzie said, August 19th. Children, all the children have gone to this particular daycare provider. And it's true that she's retiring, but the concern that Mr. Fields had was that when he had the child returned to him at the end of Ms. Bird's summer parenting time, that he needed to make sure that he had a spot for Grady to go so he could work. So he kept that spot throughout the summer.
What good did it do to keep the spot if the woman was retiring and there was no spot to fill?
She was retiring when school started.
Okay.
So she was going to continue to take the children for the summer. So there was that period of time between when parenting time ended and school started that she was going to continue to take care of Grady. And this is a person who's had Grady since forever.
Okay.
And he's
now, in your answer, you deny that the defendant was paying a portion of the child, basically child care after the May date. But obviously, if she's paying her child support, then there's child care expense included in that. She's still paying something. Isn't that correct?
Not really, Your Honor, because one, she wasn't paying her child support, and two,
I know, but that's an arrearage, but she's still on an obligation to pay it.
So she had an obligation to pay her portion of Mr. Fields' 1/2 because they have a disparity in income. They don't equally split childcare according to the formula.
I understand that, but she is paying childcare pursuant to the UCSO.
She's paying a portion of it, but because she wasn't paying her portion to Debbie, to the daycare provider, Mr. Fields had to pick up that payment on her behalf. I could
Okay.
go back and recalculate it and from that period of time and give Mr. Fields the sole obligation for the childcare and resubmit a support order that would probably increase Ms. Bird's arrearage.
Well, I'm not gonna let you retroactively go back and redo those. I mean, the order is the order, and that's the order that the court has to enforce. What the court's gonna do is, I do note in this matter that, again, as acknowledged, that the child care cost in this particular matter for the two children is $137 per the two children. If I figure that out over the 3 months that she had paid, the March, April, and May, that only brings the amount that to $411. And the other issues about the summer and all of that isn't pursuant to any order in this matter, so I'm not going to enforce something that hasn't been ordered in this particular case. So it does appear that, again, pursuant to the UCSO, that she was to pay that amount for those 3 months. The court will order that, again, the plaintiff would reimburse her for those 3 months in the amount of $411. As it relates to the insurance, she paid it in error. She acknowledges she paid that in error. She didn't pay it to the plaintiff, and he's not been enriched in any way because she paid it in error. So her recourse, if any, is against the insurance company for, I guess you'd say, improper payment of that, but it had nothing to do with the plaintiff. So I'm going to deny the request for the reimbursement of the insurance proceeds that she voluntarily paid in error. So that will be the order. If you can prepare it and submit under 7-day notice.
I will, Your Honor. Your Honor, can
you.
we do the 411 as a credit against the arrears?
We can do it as a credit against the arrears. That's not a problem.
Thank you.
Okay, thank you. Have a good day. Court will note the appearance of Ms. McNiff on behalf of the plaintiff. And it's my understanding, Ms. Henderson, you're representing defendant. Is that correct?
No, Your Honor, I am actually the GAL for the minor children.
Okay, I wondered how you were involved. I saw that Ms. Canfield was no longer, so I wondered if, okay. Court notes that this matter is before the court on the plaintiff's objection to the referee order of August 9th, 2024, as well as the motion regarding parenting time. Go ahead, Ms. McNiff.
Your Honor, as you know, this case has a kind of long and tortured history, and we've had many hearings before the referee in this matter. I understand the referee's frustration. I think we're all frustrated with this case. However, the referee did not wait to hear testimony from the child's therapist, Winnie Wallace, or from Dr. Haugen, who performed psychological evaluations for both parties. The referee also wasn't able to hear any testimony from the doctors who performed psychological evaluations on the children. And those evaluations did find that the children have some rather serious issues. The referee then
Ms. McNiff, to
reinstated.
clarify, are there still pending hearings in this matter?
Well,
That's what I got the impression, that there were still hearings where they would hear from Dr. Haugen and from Ms. Wallace.
that would be my hope. My understanding, we don't have any more hearings scheduled. So I think it would be beneficial to go back and have at least another hearing so that the referee could hear from those people. In the interim, the referee reinstated parenting time, and while it was supervised, it was going fairly well between dad and the minor son. The minor daughter is a whole different matter. However, once the referee lifted the supervision part of that, it became problematic. And as a result, now the minor son is refusing to go. And I believe Your Honor recently signed a PPO for my client with regard to Mr. Schmidt. Mr. Schmidt has been having temper tantrums. The police have had problems with him. He's called the police horrible names. He's pounded on my client's car. He's reached into it. He's terrified the child. And now we took 2 steps forward and 10 steps back with this situation. Dad and the children still have not received any meaningful reunification counseling. We've had several. We had Meridasa Cats. She got out of it. We had Margaret Hunter. She recommended that there not be any unsupervised parenting time. And then she resigned from the case as well. I really believe we need a reunification counselor. If we can find one, finding a reunification counselor right now is really difficult. But in the meantime, I believe the referee's order needs to be set aside and hearings need to resume so that the referee can get the entire picture. And of course, as the court knows, referee's time is limited. And so sometimes we've only had like a couple of hours, you know, and that just hasn't been enough time to get all of the professionals in order to make a proper record and to get the facts out on the table so that the referee can make an informed decision. But that's really what we're asking for, is to set that aside. Let's go back. Let's have these other people weigh in about what should happen. And maybe in the meantime, we could try to work out another counselor for reunification counseling. We've also not had a lot of input from defendant's counsel. She's been absent quite a bit from negotiations and difficult to reach. I understand now that she's going to be withdrawing, so maybe with another counsel involved, that will help matters. But that's the basis of our request. And then I have my other motion asking currently to suspend parenting time. I think we need to reset. We need to regroup. The child needs a break from these attempts at parenting time. And we need to get some professionals involved again.
Okay, thank you. Mr. Schmidt, what's your response?
I'm requesting for an adjournment so I can have counsel here.
Okay, are you going to be able to get counsel within a week?
2 weeks maybe.
Okay, well, why don't we do that? I'll adjourn it 2 weeks. So you can have counsel present, but again, you're going to have to do that. I'm not going to adjourn it any longer than that. So
Okay.
sorry to make you go through all that, Ms. McNeff. Wasn't aware of that. So we'll be back in 2 weeks.
Thanks, Your Honor.
Okay.
Your
thank
Honor,
you.
may I please ask a question on behalf of the minor child, Ben? Is the court making any decision today pending the hearing on the suspension of parenting time?
I am not.
Okay, thank you.
Court will note the appearance of Ms. Storm on behalf of the plaintiff, Mr. Hollick on behalf of the defendant. This matter is before the court for, again, the defendant's motion to dismiss their parenting time complaint and the defendant's motion to modify custody and parenting time. I have no problem with you withdrawing your complaint. That's totally up to you. And that is still what you wish to do, Mr. Hollick?
Yes, Your Honor.
Okay. And that will be accomplished. We'll proceed with your motion to modify custody and parenting time. Go ahead.
Yes, Your Honor. In discussions with my client, he is asking that parenting time be modified due to the fact that his parents have now moved closer and they're able to provide care to the child, and it would be in the best interest of the child to spend more time with his grandparents. That in my client's belief constitutes a meaningful change in circumstances which the court should consider, and is therefore asking that the court provide him with 50-50 physical custody of the child. While he works, the child will be watched by his parents, so the child will be with family at all times, and that is certainly in my client's estimation much preferable to the child being in daycare for a sizable portion of the time, which is where the child is currently spending a good deal of time, and that is what my client is funding also, the child care through child support. So for these reasons, we're asking that it be modified and court order an evidentiary hearing.
Okay, thank you. Ms. Storm?
Your Honor, we believe that these alleged changes are not sufficient to change custody at all. As the court knows, it requires a significant change in circumstances or proper cause that is above and beyond normal life changes. Moving your grandparents, moving closer to the children is not a proper cause or change of circumstances to change custody or parenting time. And the desire to spend more time with grandparents also is not proper cause or change of custody to change of circumstances to modify custody or parenting time. These again are normal life changes, and normal life changes do not merit a change of custody, physical or legal. Defendant has provided no allegations or issues that would rise to that level. And frankly, just because this is all based on child support for defendant. He believes that he is paying for daycare. He's got it factored into child support, and that's it, Your Honor. My client pays for childcare. Addition to that, my client also works and does not have the ability to run out to the paternal grandparents for daycare. She would still need daycare during her time, even if the court was willing to grant this change. But there's no need for this change. Frankly, defendant has been using the child as a negotiation tactic and trying to hold the child over Ms. Robinson's head. He has specifically said in text messages, if I get her more, I pay less, because he wants to pay less child support, Your Honor. He doesn't care about actually having the time with the child because he doesn't have that ability to spend the time with the child. It's in fact asked for so that his parents can have more time with the child. Again, that's not what the court is here for. This court is here to determine parenting time between mother and father, not third parties and grandparents. Let's see. He makes false accusations against my client and is specifically telling my client that unless she gives him more time and respect, he's going to continue to harass her this way. This is simply an attempt by the defendant to harass my client once again, because when he found out that his parenting time complaints were going to be dismissed, he asked for them to be withdrawn at our hearing before the referee, and then now has filed this other motion alleging things that are not true and certainly would not be in the minor child's best interest. It is motivated 100% by a desire to lower his child support obligation. And that in and of itself is not enough to modify custody or parenting time. So we ask that the court actually deny the request.
Okay, thank you. Well, in this particular matter, as the court reviews the pleadings and as well as the argument today, court will note, court does not believe that there's any basis for modification of custody. Not even come close to meeting the Vadvarka threshold for an evidentiary hearing, so the court will decline that particular motion, although pursuant to Wright versus Shea, that there is in fact always opened a basis for review of parenting time. So the court's going to refer the parenting time issue to the referee for consideration in this particular matter. That will be the order of the court. The court will do the order of referral. You're free to go. Have a good day. Court will note the appearance of Mr. Unlough on behalf of the plaintiff in this matter. The matter is before the court on the plaintiff's motion to enforce judgment and order in this particular matter. Go ahead, Mr. Unlough.
Good morning, Your Honor. I believe our motion to enforce judgment and order speaks for itself. I do have a couple of clarifications. The first is as it relates to the pension, there is a typo in the requested amount owed in paragraph 11. The amount that plaintiff is owed is $5,870.83 as it relates to the pension for payments missed from November 2023 to May of 2024. Secondly, as it relates to the enforcement of the previous order regarding the show cause regarding joint debt. My client emailed me this morning a document from her accountant indicating that she will actually be receiving $3,567 less from her tax return as a result of the defendant's misconduct, as opposed to the $2,792 that we asked for in the motion. As it relates to the defendant's response, he indicated that the pension income tax was being taxed at 22%. That is simply not the case. My client's checked, and it is in fact 4.25%. So with that, we're asking that the court order the defendant pay my client the $5,870.83 for pension payments that were missed from November 2023 to May of 2024. And then either pay my client the $18,839 he fraudulently claimed as her income, or the difference in the amount of her return amount, which is $3,567. And further, we would ask that the defendant pay our attorney fees of $700. All of that within 30 days of today's date. Thank you.
Okay, thank you. Mr. DuPont, I've read your answer. Anything else you have to add?
Only that both CPAs, my CPA and her CPA, collaborated regarding the K1s. The plaintiff did issue me a K1 for Van D LLC, which was a joint enterprise, which was awarded to her on the judgment of divorce. In addition, I agree there's money owed, and the numbers I came up with the percentages directly from my CPA regarding the taxed amount, which brings the amount owed to Ms. Van Deventer DuPont of $4,546.24. And that is accurate right for my CPA.
Okay. Mr. Unlough, what do you say to that as it relates to the tax amount?
Your Honor, the as it relates to the taxes, the amounts that we requested, the amount that we've requested today is the accurate amount per the email that I received forwarded from my client from her CPA, which was, whose name is Brian Lindbergh's office in Richland. Pardon.
But what you've stated, when you just stated today, is that amount that you're saying would have been the amount that she had to pay in taxes would have been less than what Mr. DuPont is stating is owed to her, than the $45,46.24.
Certainly, we would go with.
Okay.
If in that case, we would go with the higher amount.
Okay.
My apologies.
Well, that's what I was looking for. The court does note that, again, there's not been any, not contested that she wasn't paid the appropriate amount from the retirement pension. In this particular matter, the court's going to order that the defendant would pay the sum of $5,870.83 within 60 days of today's date, that he would pay the sum of $4,546.24, which is the amount for the that she had to, in fact, amount that she received less from her tax refund in this matter. That would be paid within 60 days. And the court would order the payment likewise of attorney fees of $700 to be paid within 60 days as well. So those three amounts you can include in the order, Mr. Unlough, and submit under 7-day notice of entry.
Thank you, Your Honor.
Thank you. Court will note the appearance of Mr. Todd on behalf of the plaintiff in this matter. The defendant has not appeared. Is now 10:35 a.m. It was set for 10 o'clock. Please mute Christie, because it's coming through as echoed again and repeated. As a result, again, he's not filed any responsive pleadings either in this matter. So the court will grant the requested relief in this matter, which would order that the plaintiff may remove the tanning bed from the defendant's possession on Saturday, September 21st, 2024 at noon. That defendant would pay to her the sum of $6,646 forthwith. That he would pay to her one half of the $7,500 COVID refund credit, again, forthwith as well, and that the payment of those two amounts would again constitute a lien against the refund credit, because it was uncertain, Mr. Todd, as to whether he had that. So I want to make sure that if he is not, and it's not been negotiated, that the amounts, well, the 6646 would be a lien against that. And then that way she makes sure she gets it at the time that they split up that refund credit. But the court would grant to the plaintiff a writ of garnishment, attachment and or execution as necessary to collect those funds in the event that they are not paid.
Got it. Great. Thank you, Your Honor.
Okay, you can prepare that order, Mr. Todd, and submit under 7 days.
Great. Thank you, Your Honor.
Thank you. Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the defendant's motion to show cause. Is that accurate, Ms. McNiff?
It is, Your Honor.
Okay. Mr. Edwards, you can proceed.
Yes. Yes, Judge, I would like to say in regards to the plaintiff's response to what took place, the judgment of divorce was granted on 6/27/2024, and my attorney advised me not to sign the quit claim deed until he spoke with her attorney, because there is a provision in the judgment of divorce that it could be used for the deed transfer. However, my attorney had to sign a quit claim deed on the beginning of July. The plaintiff then got a quit claim deed filed with the Calhoun County Register of Deeds on July 18th, 2024. So the property has been deeded in the plaintiff's name since July 18th, 2024. The records on the property refinance is to really, as to whenever she has really taken the steps to obtain a loan. She obtained a loan due to previous knowledge of the financial history during the marriage. She has failed to pay me the amount on the house, Judge.
Okay, let's ask Ms. McNiff why that is.
Your Honor, as soon as my client received the deed, she started on the refinancing track. She's been in contact with the loan officer. They hope to schedule the closing by the end of this week. The closing won't take place probably until the end of the month. And then she'll have about 3 days after the closing because of the rescission period to be funded. So we would anticipate that she'll have the funds at the end of this month, the very beginning of next month. It'd be very simple to order her to pay Mr. Edwards within 48 hours after she receives that funding.
Okay, Mr. Edwards, what are your thoughts?
My thoughts, I have talked with the city of Battle Creek this morning. She has bounced the check on the taxes.
Sir, I'm not concerned about that. The issue is her paying you the monies owed on the house. So she's saying that that'll be payable to you by the end of the month or beginning of October at the latest.
Okay.
Do you have any issue with that?
Yeah, I have no issue with that, but her financials, I have a issue with that. I would like something that's showing me that there's a loan in place, because,
Okay.
you know, this was March was the mediation.
Well, but
she's
the
had,
judgment of divorce was the end of June. We can only go from that, sir.
right, I understand.
Okay. Well, what the court will do in this matter is the court will reserve on your motion at this point to see what she does in this matter as far as those funds. The court would order, Ms. McNiff, that your client would pay statutory interest on that $60,000 from the 60 days post judgment, which puts us probably on August 27th. So she'd have a month or a month plus where she'd have to pay some statutory interest as well. You understand what that's going to do, Mr. Edwards, that you'll get your money and you'll get the interest on that money from and after the 60 days.
Okay.
So, Ms. McNiff, if you would you prepare an order to that effect?
Well, Your Honor, and I can calculate that interest rate as well.
Okay. and submit that under 7 day.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.